Marriage changes everything legally. Part 2, how marriage affects the rest of the world. In the first part of this series, we talked about what marriage does automatically, even if you do nothing. Today, we are going to talk about what marriage changes when other people get involved. Because marriage doesn't just affect you and your spouse. It affects how creditors, courts, and the government can reach your life. Hi everyone, I'm Shari Rivkind, co-founder of bridelawyer.com. I've been a lawyer for 38 years and I'm the mother of 4. And this right here is the part no one likes to talk about. But it's also the part that causes the most damage when people don't understand it. Section 1, debt in marriage and in divorce. Here's one that really surprises people. Can debt incurred after marriage legally affect both spouses, even if only one spouse created it? Yes, it can. Marriage can change how debt is treated. But how that plays out, especially in divorce, depends entirely on the kind of state you live in. And just to be clear, debt has implications during marriage too. But divorce is usually where people feel it first. So that's where we're going to start. How debt is treated in divorce. There are 2 systems in the United States, and they handle marital debt very differently. Community property states we'll start with first. In these states like California, Texas, Arizona, and a few others, the rule is simple. Debt incurred during the marriage is presumed to belong to both spouses. Period. That's true even if only one spouse signed for it, the other spouse didn't know about it. The purchase mostly benefited one person. We're talking about credit cards, car loans, medical bills, business debt, student loans taken out during the marriage. In those states, marriage creates a shared financial unit, and debt is part of that unit. So when someone asks, wait, am I responsible for this? The answer is often yes. Equitable distribution states. Most states, including New Jersey, New York, and many others, use equitable distribution. That does not mean an automatic 50-50. It means fair, based on the circumstances. And despite what people assume, courts are not allowed to simply divide everything down the middle by default. In New Jersey, case law is very clear on that. Courts look at questions like, when was the debt incurred? Was it incurred during marriage? What was it used for? Did it support the household or family in any way? If debt was incurred during the marriage for marital or household purposes, courts often treat it as a marital obligation. Even if only one spouse signed, the other didn't approve, the spending was never discussed. So when someone says, I didn't sign for that, it may not matter. Important exceptions. Courts are far less likely to treat debt as shared when it was incurred after separation, like when one spouse moves out of the fixer-upper and into a luxury high-rise with rooftop amenities and a suspicious number of 20-somethings. When it was purely personal, clearly, like deciding that an impending divorce is the perfect time to buy a brand new Mercedes convertible. If it involved secret or reckless spending, a Pretty Woman level shopping spree right before the breakup. If it was tied to gambling, an affair, or similar conduct. A Cancun trip charged to the credit card that you definitely didn't go on. In those cases, courts may assign the debt solely to the spender, adjust the overall division to account for it. But here's the key takeaway. I didn't know about it is not the same as I'm not legally affected by it. Marriage doesn't just share income, it also share debt. Depending on where you live and how that debt was created will help determine it. Or more plainly, love doesn't cancel creditor rights, and the bank does not care that you didn't discuss it first. Section 2. Judgments, lawsuits, and third-party creditors. This is where marriage really intersects with the outside world. If one of you owes money, gets sued, and loses, what you get is called a judgment. And no, it's not the kind of judgment your dad gives you when you leave the house wearing something questionable. It's a legal judgment. And that judgment doesn't just stay theoretical. In many states, including New Jersey, a judgment can become a lien against property titled in that spouse's name, including real estate. That means it can attach to a house or condo, it shows up like a mortgage, it can block a sale or refinance, and you won't be able to give clear title until it's resolved. So can a creditor force the sale of a marital home when the judgment is only against one spouse? It depends entirely on how the home is actually titled. If you've got a tenancy by the entirety, which is a special form of ownership available only to married couples in some states, creditors of only one spouse generally cannot force a sale. The creditor can't seize or partition the property. At most, the creditor's going to have to wait till the house is sold voluntarily, it's refinanced, the marriage ends, or the debtor's spouse's interest otherwise becomes reachable. If you have a joint tenancy or a tenancy in common, then a creditor of one spouse might be able to pursue that spouse's ownership interest. This can result in a court-ordered sale so the creditor can reach that share. And yes, the innocent spouse can be affected, even if they did nothing wrong. There are some protections. Some states, like Florida, have strong Homestead laws that protect a primary residence from forced sale by most judgment creditors. But these protections vary widely, and they have exceptions. Which brings us to the worst exception of all, Section 3, Bankruptcy. Different rules, bigger powers. If one spouse files bankruptcy, the rules change. A bankruptcy trustee has far broader powers than an ordinary creditor. The trustee can analyze ownership interests, determine whether property is marital or separate, and in some cases force the sale of property to reach the debtor's spouse's share. I've seen this happen. A client had purely business-related debts. He filed bankruptcy. The couple tried to refinance their home but couldn't do it in time. The trustee forced the sale of the house. The non-debtor spouse received half of what was left after costs and subject to some limited exceptions. The trustee took the rest. In many cases, trustees try to negotiate a buyout. But yes, a forced sale is possible. Section 4. What ordinary judgment creditors usually can't do. Most judgment creditors can't take property owned solely by the non-debtor spouse, cannot seize what does not legally belong to the debtor. But again, how property is titled and treated during the marriage matters. That's why it's in my name and it's in our name are very different sentences legally. Section 5. And then there's the IRS. The IRS plays by entirely different rules. When the IRS files a federal tax lien, that lien attaches very broadly, can reach jointly owned property, can override state protections, including homestead laws and tenancy by the entirety. Does not disappear because you didn't know. Federal law trumps state law, which means protections that stop ordinary creditors often do not stop the IRS. Section 6. taxes and joint returns. I know, taxes, yuck. Once you're married, you generally have two choices: married filing jointly, married filing separately. If you file jointly, you are both legally responsible for the accuracy of the return, the tax due. That means if one spouse underreports income, one spouse takes improper deductions, or taxes go unpaid, the IRS can pursue either or both of you, even if only one spouse caused the problem. That's called joint and several liability. Marriage didn't cause it, the joint return did. If you file separately, generally you're not responsible for your spouse's separate tax liabilities. But you might lose credits and deductions, your tax rate may be worse, and shared assets still matter. It's not wrong, it's just a trade-off. There are protections like innocent spouse rules, but they are not automatic. They are very fact-specific, and they're not guaranteed. What do you remember here? Creditors don't divorce you, they follow the assets. Marriage doesn't just change how you and your spouse relate to money. It changes how the outside world can reach your life. In the next video, we're going to talk about what happens if something happens to one of you and who actually gets to decide. And I promise you, this isn't about fear. It's about making sure love, not chaos, is the decision maker. Thanks for watching. See you on the next one.